to be relevant. It has to be something that was used at the scene of the crime or that has some relevance to the case. And the burden of showing the relevance of that particular item is upon you. And so you're going to ask some questions such as these. Now, Mr. Smedley, in looking at this notepad, do you notice anything about that notepad that's different or unique? Well, yes, I do. It's a yellow notepad, 8.5 by 14, and it contains 50 sheets. What is it about that that is unique? Well, this is a brand new notepad, and it only has 38 sheets. I see. Have you ever seen this notepad before? Yes, I have. I saw it at the scene of the crime. I see. And how did you see it, or under what circumstances? Well, the circumstances for which I saw this yellow pad was at the scene of the crime. I noticed there were wadded up pieces of yellow pad or yellow paper all around the crime scene, and I bent over and picked up this pad, and I noted that it had 3 blood specks on the back cardboard, of which there are 1, 2, 3 black specks, and there are 12 missing pieces out of the back of the book rather than out of the front of the book. And that's the reason that I know that this is the same yellow pad that I saw at this crime scene. You see, that person then knows so much about this yellow pad, has positively identified it by the 3 blood spots on the back cardboard and the 12 missing pads, and you can count them, and there's only 38 left. It's obvious that this man has some information about this pad. And so, now, Your Honor, I'd like to move that this be admitted as evidence. And so then the bailiff will take it, and they'll take it over, admit it as evidence, give it to the judge, he'll inspect it, give it to the opposing attorneys, they'll inspect it. If the opposing attorney has any objections to the introduction, he has an opportunity to do that. If the judge has any objections to the introduction of this as evidence, he'll do that. And conversely, you have the same rights. Now, what if the prosecution is trying to introduce this piece of evidence against you as an example? What is it that you're looking for that you're going to object to? You see, you can object to the introduction of this for a number of reasons. Irrelevance is one. Maybe the witness is not qualified to look at it. Let's analyze it for a moment. The witness had inadequate opportunity to observe or has any first-hand knowledge of the facts. So let's run over that one again. Now I'm going to send you a list of these 27, actually there's about 30 I guess, about these 30 objections that you're going to make. But I want to show you how I would object to the introduction of this. Let's suppose the prosecutor was trying to introduce these under the same circumstance. I'd say the witness had objection, Your Honor. Now, what is your objection, Mr. Gordon? My objection is that this witness had inadequate opportunity to observe or first-hand knowledge of any facts concerning this piece of evidence. Now, the burden is upon the prosecutor to prove that this witness had first-hand facts, that he knew it, saw it, put his name in it, or something of that order. But I've got a right to challenge this witness. Where were you standing when you saw that yellow pad? Well, I was standing on the other side of the room. Did you leave the room at any time? Well, yes, I did. Were there any other yellow pads in the room? Yes, there were 6 other yellow pads in the room. And when you left the room, was it possible that somebody had taken some pieces of some of the other yellow pads? Well, I guess it could have been. Well, Your Honor, I object to the introduction of this evidence for the reason that this witness cannot testify as to the proper foundation for admitting this particular tablet into evidence. He left the room, number one. We know that he's not a person who had the first-hand evidence because while he was gone, either before or after, someone else may have taken 1 or 2 pieces of paper off of the other 5 yellow tablets and thrown them around the room. You begin to see the example? And so when you're introducing evidence, if you want to get good at this, and of course I'm assuming and hoping that you will, when you read Bell's Rules of Evidence, that'll expand your horizon just that much more. And remember this, that there isn't anybody, including lawyers, that can remember all of these. And I got these from a lawyer who's been practicing law for about 14 years in criminal law, and he gave me these 27 specific objections and explained them to me. That doesn't mean that there aren't 35 or 62 specific objections that may be made, but what it shows is that there are at least 27. And if I can relate to you those 27, and you go into the courtroom and you're up against an attorney or another lawyer or a prosecutor who only knows of 4 or 5, the typical are hearsay, leading and suggestive, asked and answered, and no proper foundation. I've been through, I don't know, maybe 5 or 6 jury trials, and do you know that every time I walked in there, they always scream hearsay, leading and suggestive, asked and answered, argumentative, that's another one I've heard a couple of times, and irrelevant and immaterial. And that's about all that you heard when you were watching Perry Mason. Have you heard of the forked question? Objection, Your Honor. The prosecutor is asking a forked question there. What that means is a forked question is the question that's makes you guilty whether you say yes or no. That's the one that goes something like this. Are you still beating your wife on Wednesday nights? You see, if you answer that forked question, yes, then you've made an admission. If you answer it no, what you're saying is, well, I used to beat her on Wednesday nights, but now I've changed it to Thursday morning. So no matter how you answer that question, yes or no, it's up to you to object to the prosecutor's question. Anytime you hear a question on that courtroom, you listen to it, and he'll say, well, what did you hear from Mr. Smedley? Objection, Your Honor, hearsay. Why is that hearsay? Okay, first of all, let me explain to you what it is about these objections and why we have objections in the courtroom. All objections follow your constitutional rights. The hearsay objection follows this constitutional precept, that you have the right to confront and face and cross-examine those witnesses that are used against you, your adversaries. That's from the Sixth Amendment. As soon as the policeman on the stand is sitting there and the prosecutor says, what did you hear Mr. Gordon say? Objection, Your Honor, that's hearsay. You see, that policeman can testify as to what he knows, but he cannot testify as to what anybody else said, because you have a right to bring that person in and to put that person on the stand and cross-examine him and to have that person corroborate the policeman's story. Now, in watching this trial, you watched literally dozens of leading questions, forked questions. You saw so many errors and mistakes. Now, I want you to go back over those. You should. Go back over them when you've taken a look at these 27 objections or rules covering objections so that you can see, one, how it's normally done, and then number 2, armed with this information, you walk into the traffic court and the prosecutor, fresh out of law school, says, and what did Mr. Gordon say when he got out of the car? Objection, Your Honor, that's hearsay. That officer cannot testify as to what I said. Only I can testify as to what I said, and whether I take the witness stand or not is up to me. If I decide to take the witness stand, the prosecutor can ask me what I said to the officer. The officer can testify as to what he said to me. But the officer, with these exceptions, now I should say there are a number of exceptions to the hearsay rule. And you'll have to get those exceptions out of Bell's Rules of Evidence, and partly from experience. One of the exceptions as an example to the hearsay rule would be this. Let's say you've got a man who's dying, and you come up to the body, or up to the man before he becomes a body, he's not dead yet, and he says, it was Charlie Jones shot me, and he dies. All right. Well, now, can you testify as to what he said, even though that's hearsay? Well, yes, because he's dead and he can't come into the courtroom. And that is an act that's done spontaneously. Whenever there is some spontaneity to something that is said, that is an exception to the hearsay rule. And I've heard it said that there's no end of exceptions to the hearsay rule. I don't believe that for a minute. There are a limited number of exceptions, that being one of them. Let's say, as an example, you hear gunshots. Bang, bang, bang. And you say, what was that? And you run through the door, and here's this man standing there, and he says, I didn't mean to shoot him. It was an accident. You see, you can testify to that because right after the event, there was a spontaneity of expression by that fellow. And so when you're asked the question, well, what did Mr. Jones say? He said, it was an accident. It was an accident. I didn't mean to shoot him. You see, you can testify to that. But let's say that, a week later, you're talking to this fellow and he says to you, it was an accident. I didn't mean to shoot him. And now you go to court and someone, either the prosecutor or the defense, asks you the question, well, what did Charlie say? Oh, he said it was an accident. He didn't mean to shoot him. The difference is the time lapse between the spontaneity of right at the scene and a week later or a month later. So when the question comes out of the prosecutor's mouth, and what did you hear Mr. Johnson say? Objection, Your Honor. That's hearsay. Okay? Now, let's go on and ask a couple of more. It's called leading and suggestive. Now, you can ask the question this way. Did you see Mr. Jones shoot Mrs. Jones? Yes. Isn't it a fact that you saw Mr. Jones pull a gun out, aim it at Mrs. Jones' head and pull the trigger 3 times? That is called leading and suggestive. I've told him the answer. He pulled the gun out, pointed it at her head, pulled the trigger 3 times. I've told this witness the answer. That's like cueing here in the TV studio. If we have an actor here that doesn't know his lines, I'll ask a leading question. Mr. Connolly, you've been a tailor for 25 years. Isn't that a fact? And he says, yes, that's right. He knows his cue. He knows his lines. If the prosecutor was on his toes, the moment I said the question, now, Mr. Connolly, you've been a tailor for 25 years. Isn't that a fact? Objection! That's leading and suggestive, Your Honor, and I object to that question. Do you know that I had a friend of mine who's been a lawyer for the same fellow for 14 years, told me that he's watched a good, crafty, skillful lawyer using these rules right here, these 27 objections, so stifle fellow lawyers, also graduates from law school, they could not ask a single question and get it right. Objected to every one of them. What's your name? Well, there's one that you probably can't object to because you have to know the man's name. How old are you? Objection, Your Honor. This man's age is not relevant to the case before the bar. Make the guy show why his being 42 years old is necessary and imperative. Well, Your Honor, the reason for that is Mr. Connolly may testify as to how long he's been a tailor. And if he's going to claim that he's been a tailor for 25 years and he's only 26 years old, I think that that's necessary and imperative for the jury to know, because it goes to show that it would be impossible for him to be a 25-year tailor in the trade. Then the judge will say, overruled, tell us your age. I'm 42 years old. You say, that doesn't mean that you're going to object to every question that's asked. But this thing of objections requires skill. Being a good objector, or a person who can object on that courtroom floor, is like being a Mark Spitz in the pool. That's only going to come from a lot of practice and a lot of training. And that's why I say, do you see how ridiculous and foolish it is to go out and sue the government, to take on a case pro se without having any training at all. We're not claiming that 30 lessons makes you the equivalent of a Clarence Darrow or an F. Lee Bailey. We're claiming that you can't even walk in the courtroom and argue a parking ticket, for crying out loud, unless you have some kind of training and background. Remember the example that I used when I said you're going to Europe and you're going to play soccer? They're going to play the game with Italian rules in Germany, in the German language, and you're going to be outnumbered 9-1. Someone is going to pat you on your little pointed head and say, good luck. That's what happens to you when you go in the courtroom. Okay, now let's take a look at another one here. Asked and answered. You can only ask a question once, and you can only answer the question once. And that's why in this book, you want to take a piece of paper and you want to write down Sergeant Smith. And you want to write down every question that you're going to ask him pursuant to what you know, because you were at the scene of the crime. After all, he's the guy that arrested you. He's the guy that stopped you and gave you the speeding ticket. He's the guy that did this. You know what he said. You know how he said it and why. And you write all those down. And you include in there any leading questions that you can get away with. For instance, what happens if you've got Smith on the stand, you've subpoenaed him in as your witness, and you get him on the stand and you say, was there another officer there? Yes, Officer Jones was there. And did Officer Jones arrive within 5 minutes of your making the stop? Yes, he did. Do you see the leading question? And did he arrive within 5 minutes? Maybe that's what you wanted him to say. Maybe he really got there 10 minutes later. And maybe there were some things that Jones didn't see, but you want to ask the question, and did he arrive within 5 minutes after you made the initial stop? And if he were to say yes, and the prosecutor fails to object, you've asked him the leading question, and he's answered the leading question, and nobody's the wiser. And the jury is sitting over here, and the record is turning around, and you've got him now with the admission that he was there within 5 minutes. And now, here's Jones sitting out in the hall. He's going to come in after Smith goes out. And Smith said he got there within 5 minutes. Let's see what Jones says. Now, in the event that they catch you at that, and the prosecutor says, that's a leading question, Your Honor, and I object, then, excuse me, Your Honor, let me rephrase the question. Always have that come back, ready to go, so that the jury can see that you're professional and that you're not a nitwit and a dope, and that you're being made the brunt of the joke. Excuse me, Your Honor, let me rephrase the question. How many minutes after the initial stop was it that that Officer Jones arrived? Now that's a proper question. He can answer that question. It was 5 minutes, 10 minutes, 2 minutes, or I don't know. If he says, I don't know. Could it have been longer than 5 minutes? I don't know. Could it have been less than 10 minutes? Yes, it could have been less than 10 minutes. Well, could it then have been more than 6 minutes? Well, yes, it could have been more than 6 minutes. Those questions aren't asked and answered. The first one was, well, could it be more than 5 minutes? I don't know. If you ask the question, well, then could it have been as much as 10 minutes? No. Well, could it have been 6 minutes? You could ask this question this many times. Could it have been 5 minutes? I don't know. Could it have been 6 minutes? Yes. Could it have been 7 minutes? No. Could it have been 8 minutes? Yes. There's a conflict in testimony. You can ask every question you want that's relevant to the case, relevant to the scene of the crime, but you can't ask the same question twice. Now, there's an exception to that. You see, on what's called the adversary rule. Now, when you're on cross-examination, in our state we have what's called leading questions to adverse witnesses. And so you need to qualify this policeman then as being an adverse witness. Your Honor, I would like the court to recognize that Sergeant Smith is an adverse witness. And for that reason, I want to examine him under the adverse witness rule. You see, under direct examination, you cannot ask leading questions. Under cross-examination, you can. And under the adverse witness rule, you can subpoena in an adverse witness and then examine him as if it were cross-examination. And that's within the rules. If the judge says, no, I don't think this is an adverse witness, then may I make a continuing objection for the record? And this is called the continuing objection. A continuing objection is when I'm going to ask this guy 50 questions and I'm not going to object 50 times that you've refused to let me ask him leading questions because he's an adverse witness. So you just do it one time. Let the record show this is an adverse witness and that I'm demanding to examine him under the adverse witness rule and that I want to make a continuing objection for all of the questions that I ask this man. All right? Now you have a thing called cumulative. Now a cumulative objection is where you're asking the question like I was just asking, could it have been 5 minutes? Could it have been 6 minutes? Could it have been 7 minutes? Could it have been 8 minutes? Could it have been 9? Your Honor, objection. This is cumulative. Well, yeah, that's true. Now, every time an objection is made, you have an opportunity to rebut. And your rebuttal should go something like this. Your Honor, it's absolutely necessary and imperative that we establish the exact time that Officer Jones arrived at the scene of the crime. Because if it were 5 minutes, it will show that I was not able or had no physical capacity to resist or to obstruct and delay Officer Smith. Because there was two of them there, and he could testify to that. If it was 6 minutes, then it's necessary and imperative that we show 6 minutes, Your Honor. If it was 7 minutes, then it's imperative that I get 7 minutes out of this man. He's got a watch. He's a trained officer. He's trained to gather evidence. He's trained to write reports. And I'm challenging this report that he wrote. And therefore, Your Honor, it's absolutely imperative that I have this answer out of him. Now the judge has got to make a ruling. If he rules against you, then you object and say, Your Honor, I object to being limited in the scope of my direct examination of this hostile witness. Because, after all, it's your prerogative to sit there as the defendant and to ask this guy these important questions. And you use these words. But, Your Honor, it goes to show that. Write that down. But, Your Honor, it goes to show that. It goes to show that I could not possibly have done this. It goes to show that he did do this. It goes to show that this guy did that. And so, it goes to show. Anytime somebody objects and you're on rebuttal, that doesn't mean that it's always going to be it goes to show. I know sometimes you'll instruct people and you'll say, okay, hit hard and heavy on this thing of asked and answered, and that's the only objection the guy can come up with. That's the only one he knows is asked and answered. And you'll go into court and watch a student perform, and during the objections, he forgets about all these others. Now, I'm going to send you a list with this lesson, and you'll have that. But it requires practice. And so if you have a group of people that you can practice with, you should stage a couple of mock trials. Each and every one of you should go to watch a trial. In fact, I like to say you should go to watch 4 or 5 trials. I was at one the other day, and I guess I'm becoming a celebrity, and there was a man who I noticed there for 2 days in a row at the trial, and I asked him, I said, are you one of the witnesses? Or are you an interested party? And he says, no, I'm just a citizen, come in to watch. Don't know anything about this, and I want to learn. And here's a guy that's probably never going to go into the courtroom, never probably going to accomplish anything constructive like changing the county boundaries of his state or getting gold and silver back on our streets again, but nevertheless, at least he was there to learn. Now, for those of us that are serious patriots and serious pro se litigants here, then it's necessary and imperative that we do at least enough to go in the courtroom to watch. And when you go in there, note down the objections that the counsel asks or objects to. And you'll find hearsay, leading and suggestive, asked and answered, no proper foundation, and argumentative, and that's about all you're going to listen to, because they don't know the rest. Now, I'll bet you if you went to watch F. Lee Bailey, you'd hear 20 or 30. So let's go on here and let's take a look at a few more. There's one called irrelevant and immaterial. And you'll hear that one used from time to time. It's irrelevant and immaterial. So let's say that you're asking questions and your opposing counsel says, "Objection, Your Honor, that's irrelevant and immaterial." It's true that the questions must be relevant to the facts as they occurred at the scene of the crime. But let's say that you're trying to get in something more than that. Let's say you're trying to show your good faith intention over a period of time, over a long period of time. Well, how do you get that in? Well, you ask the question, and then when the objection comes up, you say, "This is an exception, Your Honor, to the rule of irrelevance, in that it goes to show a long train of events that occurred that were cumulative and led up to this event. And if you'll allow me to continue on, I will show you, Your Honor, I want to make an offer of proof." Now write that down. It's called an offer of proof that this train of events that began on January the 1st and culminated at the scene of the crime on January the 21st are absolutely relevant and absolutely material to the defense in this case. Now the judge is going to rule on that, and he'll probably say, "All right, Mr. Gordon, I'm going to allow you to pursue this line of questioning, but if you fail to show the relevance and the materiality of this train of events, I'm going to stop you." You understand that? "Thank you, Your Honor." And then you'd better have your questions leading up as an offer of proof that head right to January the 21st. Failure to do that will be fatal to you. And once he throttles you down on that area of questioning, you'll never be able to recover from that again. All right? That's why it's so important that your questions be written out in advance, and that you be aware that as you start to ask questions, for instance, let's take the scene of the crime as January 21st, Friday at 8 o'clock. What happened there? Well, Gordon sold beer to this kid. And then on cross-examination, I'm saying, "Well, didn't you see 15 cases of beer behind the counter that had already been seized?" "Yes, I did." "Didn't you see 15 cases of beer the Friday before that, Officer Smedley?" "Objection, Your Honor, this is irrelevant and immaterial." "But, Your Honor, I wish to make an offer of proof that will go to show, because it goes to show that every Friday I seized 15 cases of beer and put them behind the counter. And I want to offer this proof and go back and show the history of this act that occurred on January the 21st for the purpose of showing that this person showed me false ID and that I have always done my job faithfully and pursuant to the law." Now the judge would almost have to say, "Okay, Mr. Gordon, you can go back another week," and then back another week. And that's the relevance and that's the materiality of an example like that. Okay, let's take an objection called assumes facts, not in evidence. All right? If you're asking questions, if you're clever at this, you'll get away with a lot. And if you're not clever, your opponent will get away with a lot. Before you can ask questions, there have to be facts in evidence. And this is why evidence itself has to have foundation laid. And this is why you have to lay foundation of the particular party or person, witness, etc. that's on the witness stand. For instance, you put a guy on the stand, and he sits down, And you say, would you tell us what you know about diamond rings? Objection, Your Honor. This assumes facts, not an issue. There's no testimony or evidence that this man knows anything about diamond rings or that diamond rings have any relevance or materiality in this case. And so I'd object for lack of proper foundation. And it assumes facts, not an issue. Oh, well, now what do you do? Well, now you say, well, now, would you please state your name and spell it for the record? My name is Sam Jones, and it's spelled Jones. And Mr. Jones, what do you do for a living? I'm a diamond importer. And how long have you been a diamond importer? Oh, about 25 years. And where is your office? Oh, it's down on Main Street, 204 Main Street, Boise, Idaho. And are you incorporated? Yes, we are. And how long have you been incorporated? 20 years. And do you import diamonds? Yes. How often? Every day. Do you consider yourself an expert in diamonds? Yes, I do. Have you ever testified as an expert witness in court before? Yes, I have. How many times? 15. When was the last time? 2 weeks ago. Now you've established the foundation. You've established that this guy is knowledgeable in diamonds. This guy is a paid professional. He's an expert witness. Now you can ask the question. On the night of February the 14th, did you have occasion to see a bag of diamonds in the possession of George Gordon? Yes, I did. Were those diamonds? No, they were not. What were they? Those were paste. Those were glass. All right, so that assumes facts, not an issue. You must lay the foundation and then bring forward the facts that are an issue. If the issue is over diamonds, then you've got to establish that George Gordon had the diamonds or that Sam Smedley had the diamonds, that they were or were not diamonds. And if you'll notice here, when you're using words like assumes facts, not an issue, let's say that the issue is a traffic ticket, and I bring this guy in and I start asking him questions about diamonds, and she objects. That is, the prosecutor objects and says it assumes facts, not an evidence. Well, until I can establish the fact that the diamonds have some relevance to the case, then I'm trying to get this guy to testify to diamonds when the real issue is lettuce. And so you'll be overruled on that. So you need to keep it in mind, because a lot of times they'll try to bring in evidence that will be damaging to you. Isn't it a fact, Mr. Gordon, that you've been arrested 14 times? Objection, Your Honor. That assumes facts that aren't even in evidence. Besides that, in Idaho, it's even prohibited by statute to even ask the question. But just, as an example, they're trying to show, isn't it a fact, Mr. Gordon, you've been divorced 3 times? Objection, Your Honor. It assumes facts, not in evidence. It's irrelevant and immaterial. My divorce and my marital status isn't at issue here. You see, there's a number of objections, and now the objections begin to overlap, don't they? And so what you do, if you're clever, you make the objection, and then you go down the list to see what is it in here that I can call on that particular question. And so all you're going to allow your opponent, when you get good at this, the only thing you're going to allow him to ask is, what's your name, and how old are you, and that may be in question, and where do you live, and are you male or female? Then I've got one down here that says, calls for opinion by a lay witness. Now, no one can make an opinion. The exception to that rule is if you're an expert witness and the jury is properly cautioned that this is an opinion. Now, an opinion is a conclusion drawn from facts. So, let's just, take an off-the-wall example here. Let's say you got a witness on the stand over here, and you say, and sir, do you think it's possible for a person to jump 20 feet and survive without any broken bones? Objection, Your Honor. That calls for an opinion by a lay witness. Well, you could be a doctor. And if the doctor was going to testify, do you think a person could jump 20 feet without breaking a bone? Okay, you wouldn't use this. Objection calls for an opinion by a lay witness because this guy's a doctor. He's probably set a lot of broken bones. So what you would do is you'd say, objection, no foundation. We don't know if this doctor is a cancer specialist or a bone specialist. Unless he's an orthopedic surgeon, somebody who's professional in bones, We're not going to sit here and let him testify to an opinion such as that. We don't know whether or not a person can jump 20 feet without breaking a bone. Okay, let's try another one here. Not the best evidence. There is a thing called the original and best evidence. Now, when we're talking about original and best evidence, what if the original evidence isn't there? For instance, you know, maybe you've signed a contract, and the contract had some copies made of it, and the copies were filed with the county recorder or some other source, and maybe it's in a safe deposit box, maybe it's on record at the bank, it's a tax records or something like that, and they're on microfilm at the bank. The original and best evidence would be the check itself canceled. But you know, you might have burned those up. So now, what's the next best evidence? Well, it could be the microfilm at the bank might be the next best evidence. But what if you or someone else has some photocopies of some checks? And they bring the photocopies in against you. They don't have the originals because you burned those up. They've got some photocopies, and you then say, I object, Your Honor, this is not the best evidence. The original and best evidence is available at the bank on microfilm where the custodian of the records can testify as to the safekeeping of those records. These are simply photocopies, and these may be copies made from copies that were made of bogus or fraudulent originals, and I object to the introduction of this copy as evidence. And you'd probably get away with that. But yet, you know, the IRS brings in those phony copies time after time after time, and even lawyers don't object to that. You've got to have the original check. And it's up to them to show that the original check is no longer in existence or they can't get it. Then they've got to go to the bank and get the microfilm, and they've got to qualify that microfilm record as to the person who is the custodian of those records. And they'll come in with microfilm and say, well, I've got this microfilm here, and we made these copies, and we want to introduce these as evidence. And they'll bring it over to you, and you'll say, well, I guess I don't have any objection, because you recognize that this is the evidence, all right. But it is not the original, and it is not the best evidence. And if you were to object, you'd probably get it thrown out. Or at least you'd do this. You'd make them go obey the rules. And what's wrong with that? Isn't it about time that our government officials began to obey the rules for a change? Now there's the privileged communication. Now, a doctor, a lawyer, and certain other professional people have what's called privileged communication. When you go to a doctor and you tell him you've got herpes and they check that out and you find that, yeah, that's right, I've got VD here and I've got herpes, that's a privileged communication, and that doctor cannot testify to that. Now, there are some exceptions, of course, to that rule also. But the exception to that rule would have to show that it's absolutely relevant, that it's imperative, and that it doesn't cause you any damage or harm in some other way. If you're looking at a paternity suit, if you're looking at some kind of a criminal action, you have to remember that in the rules of law, like the rules of chess, after the first 10 moves, you can never be 100% sure of what your opponent's going to do when you make your move. And you're not going to know what move you're necessarily going to make after he's made his move. This thing of privileged communication, you're going to have to use your head a little on and say, well, gosh, I wonder if that's privileged and they can't use that. On the other hand, you may be getting privileged communications out of a professional person and your opponent is not awake to that. It isn't incumbent upon you, nor is it even wise or prudent for you to refrain from asking leading questions or questions of privileged communication if it's going to help your case. Remember that the system of law in America is called the adversary system. And the adversary system is you're playing a game, and it's either you're going to win or he's going to win. And you better play the game to win. And that's why if you can ask the privileged question and he fails to object, that's his problem. That's like moving your queen out in the middle of the board and then he makes a move. Now, it was possible for him to take your queen. Is it incumbent upon you to sit there and say, oh, darn, I made a mistake. Look at that.
I moved my queen out there, and you can take him with your bishop. And I didn't see that, and I took my hand off, and so it's all right for you to take my queen. To that I say, baloney. If I reach over there and move my queen out there, and I say to myself, uh-oh, the dummy can take it with his bishop if he's smart enough to see it, and he doesn't see it, and he goes over here and moves a pawn forward, I'll just use my queen, knock off his bishop. Not only did he fail to get my queen, he lost 3 points in the process. And I'll do that to him every time I get a chance, because I know that's exactly what he's going to do to me. He's going to knock off my queen, he'll knock off my bishop, he'll do everything he can to win, including, and I've seen this so many times, they'll sit there on the witness stand and lie about you. Or the prosecutor will use every devious, underhanded trick he can think of to get a conviction against you, to put you in jail, and he knows you're not guilty of any crime. He knows that you're acting in good faith and good conscience, challenging constitutional issues. And for whatever his motivation, he says, I've got to get rid of this guy. What I've got to do is hang this guy on a cross and crucify him, because he's running around here developing a following after himself. He's a threat to my power. It's been done before, it's being done right now, it's done everywhere, and it's up to you to recognize and to thwart those challenges and to thwart those attempts to throw you in jail viciously and maliciously. All right? Let's take a break while we change the tape, and we'll go on to some more of these objections and how to use them. Okay, now picking this up again, there's two that I want to pick up right here, and it's called no proper foundation. Foundation, whether it's you laying foundation or your adversary who is about to ask questions without laying proper foundation, here's what foundation requires. It requires the person, it requires time, persons, authenticity, relevance, and place. You see, the witness cannot testify until you first establish that he was at the place for which he's going to ask or answer the question. There has to be some time involved, because, yes, he may have been at the place, but was he at that place during the time that this testimony he is about to give will be relevant? The relevance is what this man is going to testify to relevant to the case? Or was he just a passerby on the sidewalk, and in reality he didn't have any knowledge of the bank robbery going on inside the bank, although at the time the robbery was going on he walked by the bank? You could say, well, he's a witness. He was at the scene of the crime at the time the crime was being committed. To which you'd say, so what? He doesn't know anything about it. And yet, they'll use witnesses like this to testify, and they'll be using hearsay evidence and testimony. Well, what did you hear? Well, I heard some gunshots. And where did the shots come from? They came from inside the bank. Who fired the shots? Well, the robbers did. Wait a minute. He wasn't inside the bank. He can't testify that the robbers fired the shots. Could have been the teller that fired the shots. Could have been the bank guard that fired the shots. And that guy could be disqualified so easily by using these rules. So remember that the proper foundation includes the time, place, persons involved, the authenticity of the testimony. That's not authentic testimony to say, as an example, I heard the shots and the robbers fired them. That's not an authentic statement, because we've identified him as being outside the bank. And the relevance of the witness. See, he doesn't even have any relevance. All he can testify to is that there was a bank robbery. How do you know there was a bank robbery? Well, I read about it the next day in the paper. You know, when you get right down to it, a man walking down the sidewalk heard 3 shots and saw police cars coming, and then was to ask, after the police had hauled the robbers away, what did you see? Well, I was walking by when the robbery took place. He can't even testify that a robbery took place. It's hearsay. He heard somebody tell him a robbery took place. Begin to see that? I don't know how many times I've seen witnesses come into court, and I've made the same mistake myself, a number of times, in failing to challenge these types of witnesses. It's got to be an eyewitness, or it's got to be circumstantial evidence based upon facts. All right, how about argumentative? Some questions can be worded in such a way that they really don't go to getting facts or to establishing relevance. They're just argumentative questions. Isn't it a fact, Officer Smedley, that you don't like Mr. Gordon? See, that's an argumentative question. It's not relevant to anything. Maybe he hates me. But for me to ask the question, isn't it a fact, Mr. Smedley, that Mr. Gordon is a constitutionalist? Well, so I've had policemen sometimes say, well, yes. And you've identified him as such, yes. Is that a dirty word to your mind? No. Isn't it a fact that all persons who are constitutionalists are treated roughly in the jail? Objection, Your Honor, that's argumentative. And that's true, it is. But if it's at all possible, I'll get it into the record because it's beneficial to my side of the case. If nothing else, it goes to show the judge, remember, who is going to pass sentence, that these guys, even after the jury comes in with the guilty verdict, you've got the judge who's going to pass sentence, and the difference between 6 months in jail and 30 days suspended is whether or not the judge says to himself, hey, I think this guy's being put upon. And always want to remember that the same judge that listens to the case is going to pass sentence. Now, at the beginning of this film, you saw a different judge come in. And anytime you see another judge come in, you should scream like a gut-shot banshee that that's improper, that you demand that the trial judge pass sentence. And in some states, there are rules to cover that. In other states, there aren't. I saw a movie some years back, and I've forgotten the name of it, but this guy went to prison and he had about 2 or 3 different judges in on the case. You've got to have the same judge that listens to the motions that goes on to the trial who then passes sentence. And I don't know how many times I've seen judges swapped and changed, and boy, they've got to have a good reason for doing that. Anytime you see judges changed, you should object. Okay, well then let's go on here and pick up a couple of 3 more examples. I may not get through all of them because I want to cover a couple of other issues here, but cross-examination beyond the scope of direct is something that you need to be aware of, because I've seen many, many times, especially a new student go in the courtroom, and the prosecution will bring the policeman on, and then the defendant will begin to cross-examine, and the policeman will tell some lies. And based upon these lies, the average citizen gets emotionally involved. He just gets so excited. You liar, you did this and you did that. And if you do that and lose your cool, everything gets out of context. And the judge comes down on you, and the jury thinks you're a kook. And the policeman is a trained professional testifier. He goes to court probably 10 times a month. And just watch how a policeman testifies. He's trained in how to do that. And that's the way you want to testify, and that's the way you want your witnesses to testify, because that's what makes credible witnesses. Yes. No. I don't know. I can't say because I wasn't there. You see, they know some of these rules of evidence. And so they're not testifying like the housewife with 3 children, who gets emotionally involved. And, well, the garbage man was coming that morning, and he knocked over the garbage cans, and that's when this other guy came around the corner. And you see, because that's not the proper way to establish facts, figures, times, dates, and evidence. Emotionalism has got to be left out. So in any event, when you're talking about argumentative, or you're talking about a good witness in there, you want to avoid argumentative questions. And when an argumentative question is asked, you want to be on top of it. No proper foundation, you want to be on top of it on both sides. I think I covered assumes facts not an issue. And let's see, if I go on down here, privileged communication, cross-examine beyond the scope of direct. Yeah, it was on this cross-examination. Cross-examination is another thing that the lay witness is just, or the layman who is the defendant just really falls down on. We've noticed time after time where they try to ask questions that have not been asked and answered. So remember this rule on cross-examination as an example. You can only cross-examine on those particular issues that have already been asked by the prosecutor, and vice versa. Let's suppose that you're asking some questions along the line of, well, Officer Smedley, did you observe Defendant Gordon driving down Chinnan Boulevard? Yes, I did. And what did you observe? Well, I observed that he was driving a red 1965 Chevrolet automobile.